In response to petitions by the wives and children of the army personnel accused of killing 13 civilians in Nagaland in December of 2021, the Supreme Court recently put a stay on criminal proceedings against them. The court observed that the nod of the central government is necessary to prosecute army personnel in areas under AFSPA, that is the Armed Forces Special Powers Act. And since the centre is yet to give consent, the FIRs stand invalidated at this stage. In December of 2021, 13 civilians were killed in a botched-up counter-insurgency operation by a detachment led by a major of 21 Para-Special Forces in the Mon district of Nagaland. This had caused huge uproar in the entire Nagaland and had turned the spotlight back on the draconian provisions of AFSPA. Following this incident, the Nagaland Assembly, in a special session, had unanimously resolved to demand the Government of India to repeal AFSPA from the northeast, specifically from Nagaland. This act has always been infamous and has met with serious backlashes because of its dark history. Back in July of 1987, unarmed civilians were allegedly killed and many women were raped, along with 2 who were forced to give birth in front of Assam Rifles troops in what was known as Operation Bluebird. The names of Irom Sharmila, who fasted for 16 years to demand this act to be withdrawn, and that of Thangia Manorama Devi, who was allegedly raped and killed by Assam Rifles personnel in July of 2004, have become immortally associated with AFSPA. Today we take a quick look at exactly what does the AFSPA entail and why it is so controversial, where in India it is still in force. But before that, don't forget to like, share and subscribe to our portal. Armed Forces Special Powers Act is a parliamentary act that grants special powers to the Indian Armed Forces and the state and paramilitary forces in areas classified as disturbed areas. The objective of implementing it is to maintain law and order in disturbed areas. Which areas can be classified as disturbed in order to invoke it is mentioned in Section 3 of the Act. This section permits the central and state governments as well as governors to do so. The state governments can also suggest whether the Act is required to be enforced or not. But under Section 3 of it, their opinion can be overruled by the governor or the centre. Hence, regions that witness heightened tensions over religious, linguistic or racial conflict usually come under the purview of this Act. Simply put, it can be invoked in places where the use of armed forces in aid of civil power is necessary. AFSPA gives widespread powers to the forces that are not available to them otherwise. And this exactly is the most contentious point with AFSPA. The Act allows the armed forces to arrest people without a warrant if they merely suspect anybody of committing a crime or if they just reasonably believe that someone might commit a cognizable offence. They can also enter and search any house or vehicle besides destroying property that is likely to be used by militants. Additionally, the army can use force or even shoot to kill those it deems to be disturbing the law and order situation. Possession of firearms by civilians is also banned under it. The law also confers special power on non-commissioned officers. These provisions have always been in the line of fire of activists and they have been demanding at least dilution of such stringent provisions, if not deletion altogether. Another provision that has generated repeated controversy was the blanket immunity granted to soldiers for their actions under Section 4 of the Act. In 2016, the Supreme Court had struck down total immunity from prosecution for those acting under the cover of AFSPA. However, Section 6 of the Act states that any officer operating under this law can only be prosecuted with the prior consent of the central government. AFSPA can be imposed in an area or a region for 6 months at a time, after which it has to be extended if the government deems it necessary. It can also be declared partially or completely in a region. the government usually passes a special act for every region it wants to designate as disturbed. Initially, the act was enacted for the Naga Hills area and then extended to Assam and then eventually encompassed all northeastern states. The regions of Punjab and Chandigarh were under AFSPA rule for almost 14 years during the separatist insurgency. In recent years, the act has been removed from many states and regions of the northeast and is currently applicable fully only in 31 districts of 4 northeast states and partially in 12 districts. However, it continues to be used extensively in Jammu and Kashmir ever since it was invoked in the 1990s. These were a few important points associated with the AFSPA. We hope you liked this new video. Don't forget to like, share and subscribe us for more such contemporary information. Thank you for watching. Subscribe to Oneindia channel and never miss an update.